Arbitration clauses in contracts for many products, including dealership retail order forms, may soon face regulation from the U.S. Consumer Financial Protection Bureau. The CFPB has been studying the practice of requiring binding arbitration in place of class action lawsuits, and whether or not the practice negatively impacts consumers. As of May 2014, the CFPB has not proposed any regulations, but the agency will continue studying the issue to assess how well consumers understand the clauses and how arbitration compares to other forms of consumer remedy, including class action suits. While the CFPB does not have jurisdiction over franchised automotive retailers directly, the Bureau has the authority to prohibit the use of arbitration agreements if the Bureau feels it is in the best interest of protecting consumers, which opens the door to yet another agency regulating the day-to-day business of franchised automotive retailers. In spite of the CFPB's focus on the potential negative effects of arbitration agreements, there are several benefits to both consumers and franchise dealers.
Arbitration can offer a faster, simplified, and less expensive means to decide disagreements between a consumer and a dealership. In arbitration, less time and money is spent on pretrial proceedings than in court. Often, after only a limited exchange of documents, the issues are presented to the arbitrator, who decides the case one way or another. The parties can call witnesses, present evidence, and make legal arguments just as they would in a courtroom. Once a decision is reached, it is final. There are no appeals. The Federal Arbitration Act requires all state courts to respect and uphold contractual arbitration clauses, unless the arbitration clause is invalid for some legal reason equally applicable to any other contractual provision. The New Jersey Arbitration Act was adopted in 2003 and has the same requirements. Opponents of arbitration argue that it restricts a consumer's rights and forces them to litigate in an inconvenient and more expensive manner. This is not accurate. An arbitration clause in no way limits a consumer's claims, remedies, or rights. The only difference between arbitration and litigation is where the consumer's claim is heard and who decides the matter. The exact same law is applied, whether it be in arbitration or a court of law. Everything from the cause of action to the calculation of damages is the same. There should be no difference in the outcome, except that the consumer and dealer will have the matter resolved faster and with fewer delays over technicalities and procedures. As far as the cost of arbitration, many arbitration clauses state that the business will pay the arbitrator's fee up front. In other cases, the clause may allow the arbitrator to assign responsibility of payment between the two parties at the end of the proceeding.
The coalition takes no position on whether a dealer should or should not utilize arbitration. However, NJCAR will press the legislature and the courts to continue to respect the dealer's freedom to contract and continue to allow the use of arbitration agreements to provide a simpler, quicker way to decide consumer disputes in the best interests of both merchants and their customers. NJCAR thought you should know.